Hi, everybody. Good morning. My name is Matt Gioffre, and I'm here with my colleague, Dan Fierstein. And thank you guys for attending our webinar about prompt payment statutes. We also want to thank our friends at the Mechanical and Service Contractors of Eastern Pennsylvania for hosting the webinar. We really appreciate that. So today we're going to talk about a few very important statutes in the construction industry that give contractors rights that go above and beyond what the terms of their contracts or their subcontracts say. And we're going to focus in particular on CASPA, the Contractor and Subcontractor Payment Act in Pennsylvania, and particularly some of the changes to that law that occurred over the last couple of years. But we're also going to touch on similar statutes in New Jersey and Delaware. And we have 90 minutes blocked out for this presentation, but we expect that the presentation portion of it's probably going to last about an hour. So we welcome any questions that you may have that come up during the presentation. You can simply type the questions into the question section at the top of your screen, the little question mark there, and we'll be able to view those questions, and we can address them either during the presentation as we go, or at the end of the presentation. We should have some time left over. So if we go to the next slide, oh, there's us, our smiling faces. Hopefully you can see us actually live presenting. So, but before we begin, I just want to give you a little bit of background about us and our firm. Dan and I are both construction lawyers with Cohen Seglias. We've been representing general contractors and subcontractors primarily for over 10 years, and our firm, Cohen Seglias, is one of the largest construction practices on the East Coast, representing contractors and subcontractors all across the country, really, but focusing on the East Coast, Pennsylvania, New Jersey, New York, Delaware, down into Maryland, and the Mid-Atlantic region. So we've been representing contractors on claims and disputes ranging from delay and inefficiency claims, construction defects, change order disputes, mechanics lien claims, and other type of claims. And our firm, as you can see in the slide, does many other types of law and focuses on those as well. But regardless of the type of claim that Dan and I are presented with, there is usually a component of non-payment that is associated with it, either just failing to pay or withholding payment for perceived deficiencies or something like that, or other issues on the project. So therefore, regardless of the claims that we're pursuing, they usually implicate one of the prompt payment statutes that we're going to talk about today. So these are very, very important statutes in our practice, and something that everybody should know about as they go through the construction project and try to get paid. So what is a prompt payment claim? So there are claims created by statutory laws that impose unfavorable consequences on those who fail to timely pay for materials and labor provided by the contractors and subcontractors for the project. So your contract usually has a time for payment built into it. But above and beyond that, the legislature in Pennsylvania, and we're focusing on Pennsylvania right now, put out a law that says that there are specific times for making payment. And if you fail as an owner to a general contractor or a general contractor to a subcontractor to comply with those payment, the timing of payment, then there's going to be consequences in the form of interest imposed on you, penalties, and other requirements such as payment for attorney's fees. So the two main prompt payment statutes that exist in Pennsylvania are the Public Prompt Payment Act and the Contractor and Subcontractor Payment Act, CASPA, which we refer to obviously as CASPA. Public Prompt Payment Act deals with exclusively public projects, and CASPA usually deals with private projects, and there is a little bit of overlap, but you can think of it mostly as CASPA for private projects, the Prompt Payment Act for public projects. And we're going to focus, like I said, mostly on CASPA today. So CASPA itself applies to all construction contracts within Pennsylvania. So any work that's performed on property that's located within the Commonwealth of Pennsylvania, this statute will apply to, with some restrictions that we're going to get into. But it requires paying your contractor on the project and your general contractor to pay your subcontractor on the project strictly in accordance with the terms of the contract itself. Failure to comply yields interest at 1% per month and penalties, potentially, and attorney's fees. Now, these are big penalties and big dollars potentially. Interest at 1% a month is 12% a year. So you're not going to get that interest in any negotiated construction contract, and you're not going to get that interest, by putting your money in a bank, certainly at this point in time. So this is a large amount of money that can add up if balances are not paid timely, or they don't follow the steps. The owner, for example, doesn't follow the steps that are required by the statute in order to withhold payment that is otherwise due to a contractor. Penalties, in addition to the interest, are also at 1% a month. So if you add the penalties and the interest together, we're talking about 24% a year on your balance that is ultimately going to be payable under CASPA. Now, the Prompt Payment Act is a very similar statute, but it applies to construction contracts where a public entity is the owner on the project. It's structured very similar to CASPA, but some of the specifics are different. Biggest difference is that it requires a showing of bad faith in order to recover penalties and attorney's fees under the statute. The interest is still built into it similarly as it is with CASPA, but penalties and attorney's fees, that's something that is more difficult to get. You need to actually show that there was bad faith conduct in order to get to that level of recovery. It also requires payment in strict accordance with the terms of the contract, but a lot of the changes to CASPA that we're going to be talking to you about today relating to suspension of work and withholding of payment and notices and things like that, those aren't written into the Prompt Payments Act. That Prompt Payment Act was not amended like CASPA was. So CASPA now provides contractors on private jobs even greater protections above and beyond what you would see on a public job.
Yeah, and I'm going to take the baton from Matt, and before I do, you'll notice this is a theme. The interest rate under Pennsylvania's Prompt Payment Act is considerably less than the 12% annual that Matt talked about on CASPA and private. I think it's tied to essentially the Pennsylvania Department of Revenue's, interest rate for late tax payments. It's much lower. It's not as powerful. And you'll notice that as a trend when I talk about some of the other states down the road. You'll see a real distinction between the private prompt pay statutes and the public prompt pay statutes, usually because you're talking about taxpayer dollars at stake on the public projects. So let's dive into CASPA, the basics that existed before, and then what's changed over the last couple of years when the law took effect pretty much about 2 years ago on the nose. So Matt alluded to this, but in terms of the projects that CASPA applies to, we're talking private construction projects, and the real estate needs to be located in Pennsylvania. Only real private exception is for small residential projects, and you're talking about 6 or fewer units being constructed. If you're in that realm, then CASPA is not going to apply. But everything else that's private and in Pennsylvania, that's going to apply. CASPA will apply. In terms of who can make claims under CASPA, the statute defines what a contractor and a subcontractor are. And the windup is really, you're talking about the entire food chain of a project down to the second tier of subcontractors. So you're going to, general contractors are protected in terms of getting payment from the owners, the trades, some of the design professionals, and then the suppliers and sub-subs, as long as they are the second tier underneath that first tier of subcontractor. And what types of payments does CASPA apply to? In general, all the payments that would be identified in a construction contract, as Matt said, the statute makes it strict accordance with the terms of the contract, and there are real consequences for not abiding by the contract strictly. The types of payments: progress payments, final payment, approved change orders, retainage. Conspicuously absent from there is the more disputed items like unapproved change orders, rejected change orders, delay claims, things that are hotly disputed. The statute isn't really designed to deal with that. As a practical matter, when we have cases, we usually see the complaining party will usually say, look, I have this giant claim. It's made up of contract balance, retainage, and delay. You violated CASPA one way or another, and I'm gonna prove it as to everything. That's generally how it rolls out in the beginning of the lawsuit. So under the statute, what is untimely payment? When we're talking about interim and final invoices, specifically where the contractor is paying the subcontractor or sub downstream to its sub, the requirement is that the payment needs to be made to the sub within 14 days of the contractor receiving its payment from the owner, or 14 days after the subcontractor's invoice comes through, whichever one of those dates is later. And typically it's going to be within 14 days of the receipt of payment. That tends to be the later of the dates, but anything's possible. So that's what the statute requires. And there's a little wrinkle underneath here. You see the note. Contractors and subs, before that subcontract is signed, they need to know and share the due date for the receipt of payment in the prime contract between the owner and the contractor. Usually that's going to happen organically because your subcontracts are usually going to say, hey, the prime contract flows down through your subcontract, and I provided you a copy of the prime contract, and that's going to tell you what the date is for the owner to pay the contractor. Doesn't always happen, and if it doesn't, there's a real consequence to the paying party. What's going to happen is everything in the first half of that slide that ties payment to the receipt of payment from the owner is going to change. The statute is now going to presume that the owner has paid the general within 20 days of the billing cycle or 20 days after it got the invoice. It's not tying it to the actual receipt of payment, and that's the consequence for not sharing with the subcontractor when is the contractor due payment from the owner.
So just to jump in, sorry to interrupt, Dan, but it's very important in the industry, the concept of pay if paid, pay when paid, where a general contractor, for example, only has payment obligations that arise once it receives payment from the owner in the context of pay when paid. And that concept is written into CASPA, and you can take advantage of that where you won't be on the hook as a general contractor for interest or penalties if you don't pay because you haven't received payment from the owner. But in order to take advantage of that under CASPA, that provision needs to be followed, where you need to provide the date or the dates when payment are due to you from the owner. And if you don't do that, then you're at risk of, notwithstanding the pay if paid provision or pay when paid provision in your contract, you're at risk of violating the terms of CASPA itself and subjecting yourself to interest and payment. So that's something that needs to be focused on and something that we can't emphasize enough.
Yeah, and one thing you'll notice as we go through, this is a very mechanical statute, right? You have a certain amount of time to pay after you've received payment. You'll see further slides when we talk about how to withhold payment. Very technical, very mechanical. So it's always helpful to have either these slides or even a copy of the statute handy, because it's very easy to slip up, and there's a lot of traps for the unwary. For right now, I'm going to turn to the fun stuff, and that's the consequences. Matt alluded to it. Pennsylvania has got to be one of the most powerful prompt pay statutes that I've seen. There are other states that are a lot weaker. They don't have 12% annual interest rates, 12% penalties, and then I'll get to attorney's fees as well. There are a lot of teeth to utilize here to protect yourself, which is kind of the idea, is to level the playing field between the contractor and the owner, and then the subcontractor and its contractors. So 1% per month is interest for late payment. Late payment is tied to the timeframes we just talked about on the last slide. The penalty, 1% per month, that's a little bit more difficult to recover because it's about wrongful withholding. So if you're forced to file suit to recover these payments covered by the statute, you're going to need to show that the payment was wrongfully withheld. And these are some examples of what wrongful withholding could be. If an entire invoice is withheld from you and the reason given is deficient work, and the deficiency is something that's very small, but they're withholding the entire invoice, we're talking about a discrete item, that's not going to be a great look for wrongful withholding. Sometimes you might see at the end of the job, you have a lot of your unapproved change orders and your claims have been kind of pushed to the end. Hey, wait till the end. We'll deal with it at the end. Sometimes there will be a negotiation. Oh, you want the contract balance? You're going to have to give up these other claims. That's another type of evidence that you might use to show if you're a general contractor going against an owner or a subcontractor going against a contractor, to show wrongful withholding. But if you show it, that's another 12% annual in your pocket. And lastly, fees and expenses. Nobody likes to pay suits like Matt and I. It can get expensive quickly because of all of the things that are involved with a lawsuit or an arbitration. So another powerful tool here is that if you have a claim under CASPA and you are deemed the substantially prevailing party at the litigation or the arbitration, that decision maker, the judge or the arbitrator, must, it's not a permissive, must award your reasonable attorney's fees and costs. You can't contract around it. So if you're a contractor going against an owner and you are the substantially prevailing party, you've got counsel fees coming your way. If you are defending, if you're being sued for violating CASPA and you win because it was a bogus claim and you win big, that's a way you can recover counsel fees. So it works on offense and on defense in Pennsylvania. So there's a lot at play here. But I think the practical tool here, from my view, is this is all good and well at the end of a lawsuit, but it takes a lot of time and money to get there. Nobody's going to finance the litigation for you just because you might have a CASPA claim. Matt and I will use this on the front end. We'll talk about CASPA in a demand letter. If you call us up and say, I can't get paid, my retainage and my contract balance, we'll probably put together a demand letter that's going to say, hey, owner, contractor, this amount of money is owed, but it's not just this. CASPA says you're going to be on the hook for interest, penalties, and counsel fees. Doesn't always work, but it can often start a conversation early on to negotiate that closeout and spare you of the need to go all the way through the challenges and the stress of a full lawsuit. So that's another way it can be used up front.
All right, so just piggybacking on what Dan said, this is quite a hammer that contractors and some contractors have that they can use to their advantage. And balances that are owed that may be quite small or relatively small, after a couple of years of litigation, potentially, if they're going to be fought by the owner or the general contractor, those amounts can balloon. So this slide shows you some examples of cases either that we were involved with or we're aware of where there was an award of contract balance that was, a lot smaller than the total award. And so let's just take a look at, for example, the first matter, which involved a claim against an owner that's called CZ. The amount that was awarded in that case, we went to a jury trial on this in Montgomery County. We were awarded $123,000 of unpaid contract balance. And the reason why the owner didn't pay that money was because they had kind of developed a list of deficiency items at the last minute after this completion of the project. They just came up with all these items and numbers that weren't really based in reality, and were formulated, obviously, as the jury found, as just an excuse for non-payment. They weren't real issues. But you might see that at the end of your project, where all of a sudden, issues crop up just as an excuse for not paying you. And that's what happened here. So the award was for $123,000, but once you added the interest, penalties, and attorney's fees that were awarded because they violated CASPA by withholding money without a proper basis for doing so, once you add that, it went to a $400,000 amount. So it tripled, or more than tripled, the amount that the contractor was entitled to in that matter. Powell Steel, this was another jury trial that I was involved with quite a long time ago, probably over 10 years ago at this point. But that involved the project for SEPTA, and the general contractor worked out a deal with SEPTA to get final payment on that project. But that deal with SEPTA didn't include any money for its subcontractor, Powell Steel. They simply said, well, we made an agreement with SEPTA, they're not going to pay this amount, so we're not going to pay the subcontractor, even though they're entitled to $935,000, as was found by the jury. So that's a violation of CASPA. They prevented the payment from SEPTA to subcontractor because of its own actions, and violated SEPTA. There wasn't an adequate basis to withhold money from its subcontractor. That $935,000, it's a lot of money in its own right. All of a sudden, with CASPA damages, interest, penalties at 24% a year, plus attorney's fees, we're looking at $2.9 million. And the last example is another extreme example, and this wasn't one that I was directly involved with, but I'm aware of in the industry. It's a small claim against a developer. $30,000 was the amount that was owed and awarded, but there was the award was not paid, it was not satisfied, and CASPA interest and penalties continue to accrue even after you get the award in court. So for years, unless they satisfy it and pay it, that interest and penalties will continue to accrue. And this also included a lot of attorney's fees, a lot of punitive damages, and the like. But by trying to avoid paying $30,000 to a contractor, this developer became on the hook for over $1 million through the application of CASPA. So it's a very powerful statute. It cannot be ignored. And those interest and penalties continue to accrue year after year, and they really, really add up. So it's something to, it's an arrow in your quiver, definitely as a contractor. It's a hammer. It's something that we can, as Dan said, right up front at the beginning, say, this is the kind of thing that you're going to be responsible for unless you come to the table, deal reasonably, and resolve this now.
Just show them this slide and tell them that you can do it the easy way or the hard way, and then move on.
So the primary purpose, as I said at the outset, is to talk about some of the new amendments to CASPA, which happened at this point almost 2 years ago, effective October 10th, 2018. Now, frankly, CASPA is not a particularly well-written statute that leaves a lot of room for interpretation, sometimes within the new amendments as well. And there hasn't been a lot of court cases or decisions in the last 2 years, or really any at all, that have helped to interpret all of the provisions. But so, there is some room for interpretation, but based on our experience, what we've gone through, and our reading of the statute, we're able to provide our advice and explanation of what this stuff means. The reason why I bring this up now is because even the effective date of CASPA doesn't specifically say this only applies to contracts or subcontracts that are entered into after October 10th, 2018. I believe that that's what it means, and that's the most likely interpretation, but it doesn't say that in the statute specifically. But so for the purposes of these new amendments, everything we're going to talk about today over the next 20 minutes or so, just think of them as applying to most likely your contracts or subcontracts that have been entered into since October of 2018. If you have old projects that are still going on, it may not apply to those old contracts. But the purpose of these new amendments is to strengthen a contractor's rights, level the playing field even further between a contractor and owner, or between a subcontractor and a general contractor, and gives additional rights above and beyond what you have in your contract itself. So the rights that are the changes that we're going to talk about today is, one, the right to suspend work on a project in the event of non-payment. Two, the removal of the practice of requiring waiver of these CASPA rights within your contract itself. So if there's a waiver of CASPA in your contract or subcontractor, that's no longer enforceable. It also creates a new framework to facilitate the release of retainage early in some cases, and also has important terms that Dan's going to go to in some detail about timely notice of withholdings, both for an owner to a general contractor and a general contractor to a subcontractor, and subcontractors to subcontractors. It goes down the line. But that's a very important one, the timely notice of the withholdings, the withholding amount, the reasons for the withholdings. So the first one—
Matt, I'm sorry, but I didn't mean to cut you off. Before we go into your next slide, we do have our first question from the audience, which is very exciting. So the question is with regard to the notice that you have to give about when the owner is required to pay the general contractor. The question is, does incorporating the owner GC contract into the subcontract constitute notice of when the owner is obligated to pay the general contractor? Which I interpret that question to mean, is saying it's incorporated enough, or do you need to give actual notice? Here's a copy of the prime contract. Here's where it says the terms of when the owner has to pay the GC. I don't know if you have opinion on that, Matt.
Sure, and my opinion is, it says notice. It requires actual notice. It doesn't say incorporation of the contract into the subcontract. The subcontractor needs to know the payment terms, and it doesn't need to. You don't need to necessarily provide the entire contract with the owner, although that's a good practice, I believe. You can block out some of the the payment terms or percentages or whatever you need to block out. But it's a good practice overall, generally, to provide that agreement to your subcontractors, because that agreement's part of their obligations. And how do you expect them to comply with those obligations if it's never provided? And going further, what the statute requires, it requires you to provide notice of those payment terms. So you can cut and paste those payment terms and email them. That satisfies it. You don't necessarily need to provide the whole contract, but the easiest way to do it usually is just provide a copy of the prime contract that contains those payment terms. But just incorporating it without providing those details to the subcontractor is not enough. Dan, do you have any thoughts to the contrary?
No, I agree. When it comes to notice and things like that, you give yourself an argument that it says incorporated, but you're much better off if you're in front of the judge or an arbitrator saying, oh, not only did my contract say it's incorporated, here's the email where I sent a redacted copy of my prime contract with the payment terms, or the cut and paste, or whatever it is. Actual notice is going to do you a lot better, especially if you can prove in writing that you gave it.
Okay, so moving on to the first of the amendments, and probably the most significant amendments to CASPA that came about in October of 2018. It involves the right to suspend work on a project. And this slide specifically deals with subcontractors having the right to suspend their work on a project in response to non-payment. And I'm going to go through the slide and the details and the mechanism first, but the question first is why, under what circumstances would you want to suspend work? And this is obviously an extreme remedy. It is something where if the writing is on the wall that there are major problems with the project and you have not been receiving payments, yet you're going to continue to do work on the project, continue to expend money, pay your labor, pay for materials, get all that stuff to the project. Sure, at the end of the day, you might have a mechanics lien, but some people just might not be able to put all of that money out there without the prospect of receiving payment in the near term. So this gives you the option as a subcontractor or a contractor to say, enough, you can't continue to go on like this, and I see the writing on the wall for one reason or another that payments are just not going to be forthcoming. It provides you an out to get out of the project, to stop, or temporarily first, your work until you start getting payments. And I have recent experience on this, not in Pennsylvania, but in New Jersey. There's similar right where a contractor that we represent saw that the writing was on the wall and that they simply were not ever going to get paid by an owner for this project. And instead of, their contract itself did not give them the right to take a timeout and say, we're pulling off. That in itself could be potentially a breach of your contract if you stop performing. But there's a right within the statute to go ahead and suspend work on the project. And in addition to actually doing it, actually suspending work, it also creates a big threat for the owner or for a general contractor that I'm going to shut the project down. We're going to stop working. We're not going to be able to proceed until my balance gets taken care of. And it gives you the right to do that, without penalty. So there's not going to be a problem for breaching the contract. You're not going to be on the hook for the costs of a replacement contractor, replacement subcontractor, because you do this. It is a very powerful right. And the idea as it's written into the statute is you'd provide notice of this concept that you're going to suspend work for a great period of time. Actually, a total of 70 days has to pass. And during that process, the hope is that you'll be able to work out and receive payments through the owner, through the general contractor, before you actually have to pull off the job. So let's talk a little bit about the mechanism for how you accomplish this. So you have a billing cycle and you have a due date for your payment from the subcontractor. The subcontractor knows what the billing cycle is because that information has been provided by the general contractor under the statute, as we just discussed. So they know when payment should be received. If 30 days have passed after the date when payment should have been received, then they have, and that's usually, it's per your contract, or if there's not a term in the contract, it's 14 days after the prime contractor is to receive payment from the owner. So if 30 days have passed after that period of time, then you can provide a written notice to the contractor, to the general contractor, saying that you intend to suspend your work on the project because of non-payment. And that initial written notice can be sent via email, can be sent via regular mail, but it's got to be in writing. If nothing happens for 30 days after you put that initial written notice out there, you have to wait another 30 days and you have to provide written notice to the owner. So the subcontractor now writes to the owner via certified mail, not email, not regular mail, certified notice that in 10 days, we are now going to be suspending work on the project. We're going to be pulling off. So it is, you've waited the 30 days after the payment was due, you provided the initial notice, now you're providing the second notice, and after those 30 days to the owner, then you got to wait 10 days after providing that second notice, and then you can pull off the project without penalty. So it is a threat, but it's a 70-day process. So we're talking 2 months where you need to continue to work on the project despite the non-payment, but you need to kind of protect your rights, follow the notice requirements, and get it into a place where you can then pull off the project without penalty. But in the interim, the idea is that these notices to the contractor and then to the owner will light a fire under everybody to make sure that you get paid and the project continues to move forward.
So again, this is just incredibly mechanical, and it's all about days and calendars and giving the notices. So it's a lot to think about. We actually got some additional questions while you were talking. They don't directly relate to this particular issue, but why don't we work through them if that's okay?
Sure.
The first one is on a finance project where there's a lender involved. What are the safeguards that can be put into place to make sure and ensure throughout the project that there are available funds in the loan for your work? The issue being oftentimes banks will let the owners go above and beyond the threshold of the loan, and then it becomes a surprise to the contractor when now they need to collect, you know, a certain amount of money direct from the client. So I don't believe CASPA addresses this specifically. So one answer is going to be you can always try to negotiate your contract in a way that's going to give you some ability to ask for assurances. I believe in the 2017 AIA forms, which sometimes are often utilized and modified a bit. I think there's a default provision in there that gives the ability to either seek information about where the money's coming from and get assurances. So the issue, it's a great question, by the way. The issue exists. My sense is that you deal with it as best as you can through the contract. Matt, I don't know if you have any other thoughts on that one.
That your thoughts are exactly, the same as mine. It's the AIA. That's the provision, the AIA 201 general conditions. You would need to have that provision, that standard provision, or modified to benefit you in there that first gives you the owner the requirement to provide their financing information. So that's on the table at the outset of the project. And that provision also says if there are significant change orders over a certain threshold during the course of the project, then you can ask for additional assurances that these are going to be funded by the lender. Also, oftentimes you'll, as a general contractor, at least you'll have to get you have to provide some sort of assignment document with the lender. In the event of default, then that contract can be assigned to the lender, and that document oftentimes has some obligations of the general contractor to provide notice to the lender as well in the event of changes to the scope of the work that will increase over a certain threshold. So that provides another opportunity to have direct communications with the lender and make sure that those changes to the work are being appropriately financed. But CASPA doesn't, as we said, doesn't cover that. All it would cover would be, once you do that work and the lender doesn't fund the payments, CASPA doesn't care really whether the lender funds the payments to the owner or not. If you do work in accordance with your contract, the owner needs to make payment to the general contractor, regardless of whether it has funding or not. So practically, that may be difficult for an owner, obviously, but CASPA doesn't really care about that, doesn't really speak to that. That's something that you need to work into your contracts.
For sure. We have another topic, and I may try to work this in down the road when we get into withholding payment and things like that, but there's just a general request to touch on any issues to consider when a subcontractor contacts an owner to figure out when the general contractor was paid, aside from aggravating the general contractor. So we can talk about that as the issue comes up. And then there's a question, does this apply to the Prompt Payment Act, the public statute, or just CASPA? Assuming this is touching on the things that we just discussed with suspension and some of the stuff leading up with it, the short answer is no. It does not apply to the Prompt Payment Act. The only statute that was modified back in October of 18, or took effect in 18, was CASPA. So we're really just talking about private projects. Good question there. And lastly, can the general contractor fire you for giving the first notice? The assumption, in my view, being, this first notice about, suspension of work.
Absolutely not. So, this statute is built to protect, contractors and subcontractors. The whole concept of this suspension of work and following these strict guidelines, notices, and ultimately being able to walk off the project and suspend work after 70 days is that it is without penalty to the subcontractor. So enforcing your rights under CASPA and getting terminated for that reason would be a clear wrongful termination that would implicate CASPA as well as a number of other problems for the general contractor. Should not be done. So that the answer to that is unequivocally no. They do not have the right to terminate you by taking advantage of your rights here under CASPA.
Yeah, and sticking with the subject of suspension of work, if the owner does not receive the notice or refuses acceptance of the certified mail or just doesn't claim it, has the notice been made? There's a few rolled up in there. The first one, if the owner doesn't receive the notice, that's going to be a problem. So if it's a matter of the contractor didn't send it and that's why it wasn't received, I think the owner is probably okay there. In terms of refusing acceptance of certified mail or not claiming it, I would personally advise against that. It's not a great look. It will come back as refused, and then that becomes an exhibit in a future letter or a lawsuit, and it's going to look like you were just trying to duck that notice. I think you're better off reviewing the notice, responding to it. You might not agree with what's in there, and the notice might be inappropriate. They may be making misstatements, and you might do better to engage that and protect yourself with a letter back. Matt, I don't know if you have thoughts about that as well.
The obligation is to send it via certified mail to the correct address. If they refuse service, then that's on them. I would recommend in that situation you serve it a different way. You have somebody, a courier, hand it to them, or post it someplace. But your obligation is fulfilled upon sending that certified mail to the correct address. That's all that you can do. And that's all the statute requires. But I would just belt and suspenders. If they're going to refuse it, I would shove it in their face one way or another, and then go on and suspend work within those 10 days.
Great. So these are great questions. I've got a couple more, and I'm going to work them in as we continue so that we can follow through with the suspension of work here. Or actually, excuse me, we're on withholding of payment, and that's me. So you were always, go ahead, Matt.
I just wanted to go back one slide because we've been talking about suspending work by a subcontractor. If you go back one slide, this slide deals with contractors, general contractors, also having the right to suspend work. The only difference is that both the initial notice and the second notice both have to be made to the owner, obviously, and just the owner. Whereas for a subcontractor, initial notice to a general contractor, second notice to the owner. But it's the same method. First email or regular mail to the owner for that first 30-day period. And then the second notice after 30 days needs to be done certified mail. So with that, we can move on to the next important provision that was added in October.
Sure. Again, great questions. Keep them coming, and we'll definitely get to them. So the original version of CASPA, it always allowed owners to withhold from contractors and contractors withhold from subs for deficient work. That concept hasn't changed, and withholding is still allowed. What has changed is that there is more teeth for the party who is not being paid. And from the, between the contractor and the subcontractor. Basically, if a contractor has either been notified itself, maybe it received its own deficiency notice from the owner, you're going to want to pass that through to the subcontractor if it relates to their work, because that will help you justify withholding payment for that issue until they've corrected it. But the rule is that the contractor needs to notify the sub and the owner in writing within either the time specified in the contract, if it is specified, or if it's not specified, within 14 days after becoming aware of the notice of deficiency. Again, this is one of those areas where Matt was saying the statute, the new stuff, it's a retrofit, it may not be the best drafting. This is an example of that, because it's almost, you read it and it almost presumes that the contractor got a written notice of deficiency from the owner. Might happen, definitely pass it through, either within 14 days or whatever the contract says. But also, if the contractor become aware of a deficient work item, regardless of whether you heard from the owner, you're going to want and need to notify the sub in writing and the owner in writing what you're withholding and why and what it specifically relates to. This is one of those areas of the statute where you can contract around it. That's why it says within the time specified in the contract. 14 days, not a lot of time in construction world, not a lot of time when you're talking about payments between a contractor and a subcontractor. So the legislature decided to give the ability to modify the subcontract to allow for more time to give that deficiency notice. More teeth. Failure to comply with this requirement is a waiver of withholding payment for that particular deficiency. So Matt told you a story about a case where there was non-payment and there was no issues with the quality of the workmanship. But then at the end, this bogus list of deficiency items came in at the 11th hour. That doesn't work anymore, because that will have happened way too late. And the statute says, nope, that's not a defense. They might do it anyway, but if you end up in litigation or an arbitration and you can show that the deficiency came in late, the deficiency notice, then you're going to be able to win that issue as a matter of law. You might even file like a motion to deal with it and not even present evidence on the issue because of that waiver. So it's very powerful. And payment always needs to be made for completed work that's satisfactory. So the days of saying, oh, you screwed up this one issue, I know it's like a $10,000 fix, but I'm withholding the entire invoice, that doesn't work. You really want to get as specific as you can, because otherwise you're inviting the wrongful withholding and the 1% per month penalty for a wrongful withholding. So the more specific you can get about why you're withholding the money, and it's reasonably tied to the amount of money that it ought to take to fix the issue, these are the kinds of things that are going to be viewed as a reasonable, good faith withholding. Go to the next slide. Now, the owner doesn't have the same luxury that the contractor does. The owner, if it has an issue with the contractor's work, it gets 14 days to notify the contractor in writing of what the deficiency item is, why it's withholding, and how much money. And that's it. There is no reference in the statute, like there was on the previous slide, that allows the contractor and the owner to contract around that. It's 14 days. It's not a lot of time. So owners have to be hyper vigilant, and contractors could really, this could be a real advantage for the owners that have relaxed their vigilance and kind of aren't really keeping their eye on the ball. So think about that on the 14-day. And same issue, the owner waives this defense if it doesn't provide that notice, no exception. Invoicing error does happen sometimes. It's not an excuse for non-payment. In fact, the statute actually places a burden on the party receiving the invoice to advise of the incorrect issue or the error, and must still pay the correct amount when it's due. this, you may have a pencil copy process in place already, and so you may be going back and forth with your subcontractor or with your contractor about what's right and what's wrong before it ever gets sent up to the owner officially. So this may not come into play, but it is something to keep in mind. The next new tool in your quiver with the amendments is on the release of retainage.
I think,
and I skipped a slide. So
yeah,
I did. I went ahead. My got some heavy fingers there. So now retainage can be released earlier than typical. Now, a contractor or a subcontractor, when they've achieved substantial completion of their work, they can get their retainage up front by posting a maintenance bond with an approved surety at the value of 120% of the retainage amount. So that's one way. If you're really strapped for cash, it's a big nut. It's a large retainage amount, and you don't want to fool around with it. You want to get the heck out. You can post that bond and unlock your retainage. That's brand new. And posting the bond obligates the owner or the contractor to release the retainage, provided there's no written notice of deficiency. If there's a written notice of deficiency and you've done that timely, that will come into play as well. Another new concept with the release of retainage is that there are now official limits on how long it can be withheld. What I just went over was about placing a bond, a maintenance bond, to get your retainage after substantial completion. If you don't do that and you've achieved final completion, where your work has been final accepted, retainage cannot be withheld for more than 30 days, again, unless there's a proper notice of deficiency that applies. And failure to comply with this is a violation of the statute. So the legislature has protected your retainage a bit more than it had been in the past.
We alluded to this as well previously. There's also a new provision in CASPA that prevents contractors, subcontractors from waiving their rights under CASPA in the contract or subcontract itself. So, for example, I've dealt with a lot of reviews of contracts for subcontractors or preparation of subcontract forms for general contractors, and I've seen a lot of times the provision in there, even written it maybe a couple of times myself, that says as part of this agreement, the subcontractor or the contractor waives the right to the remedies provided for by CASPA. So you can't get interest under CASPA explicitly. It says that you can't get a penalty under CASPA. You can't get attorney's fees. We're going to waive the right to do so. So there was an interplay, but in the courts, courts have addressed this previously before these amendments came out and said, oh, you can waive some things, you can't waive other things. They kind of dealt with it as they thought was best. Now, explicitly, the legislature has said, forget about that, courts. You can't waive anything. These are rights that a contractor has. These are rights that a subcontractor has, and they can't give them away in a contract. It recognizes that the lack of equality in bargaining power between a contractor and owner, or between a contractor and a subcontractor, and a lot of times, you have to agree to certain terms that are unfavorable in order to get the job. So they recognize that, again, trying to level the playing field, the legislature, and make it more fair for contractors and subcontractors, and saying you cannot waive your rights under this statute, except if there are provisions in the in the statute that specifically state that it can be waived. The example is the general contractor has 14 days to provide notice of a deficiency to a subcontractor, unless there's an agreement otherwise, and that's written into the statute. That means it can be amended by the subcontract. Interest is also the interest from an owner to a general contractor. That's another one that the provision of the statute says, unless agreed to otherwise within the contract, interest is going to be enforced at this amount. Penalties, that's going to be there regardless. Attorney's fees for the substantially prevailing party, that's going to be there regardless. The suspension of work, you cannot contract around that. That's going to be a right that all contractors and subcontractors have. So if we go to the next slide, there are some things that, some takeaways from this presentation on the changes that we just discussed. Things to be on the lookout for. And the first one is, we've harped on it a lot, but the waiver of the right to withhold payment if written deficiency notice is not provided within 14 days of the invoice. So this is both applicable to owners and contractors, general contractors, if the subcontract is silent as to that time period. And generally, courts will interpret this notice provision strictly. So you need to provide that actual notice of the withholdings and the amounts of the withholdings and the reasons for the withholdings timely. It's important that you do that. And if you don't, then forget about using those deficiencies as a basis for non-payment. Also, I'm not sure if we talked about this explicitly, but it's important to note that when you provide those, okay, we're withholding payment of, $100,000 for a deficiency in this, you need to identify a reasonable amount of withholding for that particular item, and you need to pay for everything else that isn't associated with that, the cost of that with particular withholding. So just because there is a deficiency, it doesn't mean that an owner or a general contractor gets to withhold the entirety of the amount that's owed for the invoice. There needs to be a dollar value. Now, with the new statute, needs to be a dollar value specifically associated with the deficiency item that's reasonable. So again, here's a kind of a summary slide of the amendments. We talked about the right to suspend work without penalty once you jump through all of those hoops. And it's as much of a right to suspend work as you take advantage of that right to be the squeaky wheel that gets you paid on the project. So it's important to provide notice in that time frame, that 70-day time frame, allows you to have a discourse with the owner or the GC to get you paid without having to suspend work. There's requirements too for withholding payment. We just talked about that. The maintenance bond, that could be a big deal if retainage sometimes gets held on for way too long, and for punch lists that are never ending or for whatever reason. So this would allow you to say, forget about that, I'm going to post a bond. You have to accept this bond. You need to pay me all of that retainage immediately, and we'll deal with the punch list. So that allows you to just go and get that cash at substantial completion.
Matt, only because one of the last questions was on that point, and I think we've answered it, but just to underscore it, the question was, if that bond is posted, does the owner have to release it? And the answer is absolutely. It is non-negotiable. It can't be violated, or you're violating CASPA. Right.
And if they don't release it, that means that all of a sudden interest and penalties kick in. So, all right, you're not going to release retainage. It's 24% a year starting now, and that really adds up. It really does add up. Even for a month of that is a significant increase. Last couple of the mistakes on invoices, not an excuse for non-payment, and the non-waiver of CASPA protections that I just talked about. So now we're going to move on to the last kind of portion of our presentation. Is going to be just a brief comparison of the prompt payment laws in other states, and we're focusing on some of the states that we deal with most often, New Jersey and Delaware. And I'm going to talk a little bit about New Jersey. And it's the New Jersey Prompt Payment Act is the statute that is the relevant statute for that state.
So, Matt, I think this is a good point to pause and get through the rest of the questions, because okay, I do believe that most of them pertain to Pennsylvania, and we're now leaving Pennsylvania for other states. So one question is is there a statute of limitations on making a CASPA claim in Pennsylvania or the equivalent in New Jersey? I will tell you, with Pennsylvania, we treat it as part and parcel to a breach of contract claim. The statute itself doesn't tell you anything. It's almost like an adjunct, an add-on to a breach of contract, which in Pennsylvania, you have 4 years to file. So you should think of CASPA the same way you think of your breach of contract claim against your customer if you need to go get payment. It's the 4 years in Pennsylvania. Jersey, I believe, is a 6-year statute on contracts. My working assumption, unless Matt tells me something to the contrary when he goes through New Jersey, is that the Prompt Pay Act in New Jersey would function the same way. Let's go to the next question, which is, does language in a subcontract binding the subs to the terms of the prime contract between the owner and the GC automatically satisfy the requirements of CASPA if a sub is bound to the prime contract but never receives a copy, either because they didn't ask for it or the general contractor refuses to provide it? Has the GC satisfied the requirement? I do think we answered this, so I apologize if I got to it too late. But the windup is give the actual notice. It's not going to be enough to just say I gave it to you or I gave you the opportunity, but you never actually did it. You're much better off, cut and paste the payment term, give them the prime contract if they ask for it, because, if you want them to really be bound by it, you want to actually, put your money where your mouth is. Redact it. You can redact the price if you don't want to show the lump sum price and things like that. That all makes sense. But that's part of the deal. Can a subcontractor contact the owner directly regarding a payment dispute if the contract says that you cannot, as a subcontractor, contact the owner? So the answer is going to be it depends. But if you get into a payment dispute and now things are ramping up, in some respects, you have the statutory right to contact the owner, because let's say you were going to file a mechanics lien, which I know isn't the subject for today, but if you're a sub in Pennsylvania, you're going to file a mechanics lien because you're not being paid, you actually have to tell the owner in writing 30 days before you file the lien itself, because that's what the lien law says. So that's an example of where your contract might say no contact with the owner, but if there's an actual payment dispute and it might give rise to a lien, that's gonna take a back seat to the requirement to notify the owner. So Matt, I don't know if you have any filler thoughts on that, but that would be my initial thought.
The other context is something we talked about earlier with the suspension of work. So that requires a subcontractor to provide the written notice to the owner, that second 30-day period of time. So I guess 60 days after you haven't received payment and 10 days before you suspend work. That requirement to provide that notice, and that's done, it says in the statute, without penalty. You're not going to be in breach of your contract. Even if your subcontract doesn't allow you to suspend work, doesn't allow you to talk to the owner, you're not going to violate the contract or the law by actually going along with your statutory rights under CASPA. You have the right to do that, by law in Pennsylvania, by statutory law, and that will supersede the, whatever provision you have in your contract to the contrary.
So moving along here, next question is, how does CASPA apply in a situation where the general contractor did not include the subcontractor's monthly pay app in the bill to the owner until months after the sub timely submitted the pay app? And then you find out, in the present, oh, we just submitted that to the owner. So how would CASPA apply to that situation?
Well, that's interesting, because it doesn't really contemplate that. It doesn't contemplate, CASPA contemplates things happening in the normal way. General contractors generally want to pass your invoice on to the owner, want to get that payment for that work that's been performed. So there could be circumstances where they don't do that by mistake or for some other reason, maybe relating to a deficiency item. I don't know. But the statute doesn't specifically address that. It assumes that payments are going to be submitted within that billing cycle, and that when payments come from the owner, it'll be for all of the subcontractor invoices, and at that point, it's when payment becomes due. But it does have a pay when paid component built into it for a general contractor's obligation, that you would have to, they have to actually receive payment from the owner before that 14-day time frame for payment comes about. The only thing that I would think of if I were representing a subcontractor in that circumstance is there's a doctrine in the law called the prevention doctrine. And if a one party to an agreement takes some action that prevents a condition for payment, for example, to occur, in this case they take an action by not submitting that application for the owner, then they can't use that condition for payment against you. So in that situation, if they do it for no reason, I would argue that that they still would have the responsibility to make payment, and CASPA would still apply. What do you think, Dan?
Yeah, I think that's right. And in general, the law, if it's, the general purpose of the statute is to level the playing field for contractors and subcontractors who are following the rules of the game and who are following the rules of the contract. So it's hard for me to envision a court or an arbitrator penalizing the subcontractor that submitted a timely invoice, literally did everything it was supposed to do, and couldn't control what the contractor did or didn't do. I think the law, the statute would account for that, even though it's not specifically covered in, on the four corners of the statute, because at that point, you're running afoul of the general purpose of the statute. That's my view on it. Couple more, if we could get through them before we go on to the other states. This is about architects and engineers, and where the definition of sub-tier contractors includes architects and engineers. When the owner contracts directly with the architect or engineer, does CASPA cover them as the contractor? And the answer, without the statute in front of me, should be yes, because the definition of contractor is going to be one who has a direct contract with the owner for the services, that include what architects and engineers do. So that's how I would answer that one.
Right. It's a broad definition. The mechanics lien law, we talked about that earlier, has a very narrow definition of who can claim rights under that statute. It's a much broader definition of who a contractor is under CASPA, and people who provide design services relating to the improvement of a piece of real estate. That is something that is covered by CASPA, and they would also be able to use these provisions to their benefit.
Yep. Is there a specific maintenance bond form to use, or is any form acceptable? And how long does the maintenance bond need to be in effect? Is it 1 year, or is it based on the contract terms? Some of these, I have to confess, are going to be I don't knows. There's definitely not a specific form that's specified in the statute itself. I think there was a reference to an acceptable surety, which might tie into, a list of approved sureties that are allowed on, Pennsylvania projects in the public realm. But in terms of a form, I'm not aware of a requirement. There's also not a term requirement, but I would expect it to conceptually coincide with the main purpose, which is getting you through to final completion, and as opposed to all the way through your warranty.
Right.
I don't know if you have any thoughts about that as well.
I completely agree. The form would have to come from the surety itself. There's nothing in the statute that's specifically required. But yeah, the concept is that this is going to substitute for retainage. So retainage provides the owner with some security that you're actually going to come back and do these punch list items, in order to get, the carrot at the end of the stick there. So, but this kind of replaces that, and the obligations of the maintenance bond would be, I would believe, based on statute, the exact same as your obligations to complete punch list work on the project. So it would be that concept would be built into the maintenance bond rather than for.
Yeah, having given that a little bit of extra, I definitely agree with that, because think about if you don't provide a maintenance bond and you just get retainage the old-fashioned way, the statute now says you can't hold that retainage more than 30 days after final completion. So I think we really are talking about getting yourself through the punch list stage and getting that final payment before your warranty obligation really kicks in. Last question, and then we can get into the other states. Isn't the general contractor required to respond in writing if he rejects an invoice? Otherwise, isn't the invoice considered approved? It's a very logical and question that makes complete sense. I think as a general concept, yes. If you perform work and nobody tells you that there's a problem with it, forgetting CASPA, that's going to be good evidence that your work was accepted, especially if the owner ends up with beneficial use. The difference here is that the statute is coming out and saying it is a violation of this law not to notify in writing about the deficiency item. And if you fail to do that, the payment is due immediately and you waive the defense. And if you don't make it after that, then you violated the statute and interest and penalties are in effect. But yes, conceptually, you need to speak up, whether there's a CASPA statute or not, if you have a problem with an invoice or with the subcontractor's work that relates to part of the invoice. So with that, why don't we dive into New Jersey?
All right. So unlike Pennsylvania, which has two different statutes, one for the public realm and one for private construction projects, New Jersey just has one statute that deals with prompt payment, the New Jersey Prompt Payment Act. Comparatively, it's very simple and straightforward. But so we can cover it in 2 slides. So essentially, their invoices, the first key provision is that invoices from the prime contractor to the owner are deemed approved and certified 20 days after the receipt by the owner, unless the owner provides a written statement of the reasons for withholding. So it's 14 days in Pennsylvania. In New Jersey, it's 20 days that the owner has to look at an invoice and say, well, we're not going to pay it for this, and this reason. Otherwise, it is just deemed under the statute to be approved and certified, and payment is due. And payment is due under the Prompt Payment Act to the prime contractor in 30 days. So it's a 30-day payment period. And then subcontractor payments are due 10 days after the contractor's receipt of the payment from the owner, or per the contract term. So this allows some modification. So if there's no provision in the contract about what the time of payment is in the subcontract, then the payment is due to the subcontractor 10 days after receipt of payment from the owner. But it can be modified. So that's one provision where there is the ability to change the terms of the statute and modify it by subcontract. Now, instead of interest, penalties, and attorney's fees, the New Jersey Prompt Payment Act only allows for recovery of interest. And it's not 12% a year, 1% a month. It's the prime rate plus 1%. So it'll modify a little bit, but it's going to be not a significant amount of interest as compared to really 24% a year that you get under CASPA. So all you get is interest, and it allows for attorney's fees and costs to the prevailing party. And that could be the owner or it could be the contractor, depending on the situation. But it does require or provide for recovery of attorney's fees and a small amount of interest, no penalties. So not quite the same teeth that that CASPA has. So, and if we move to the next slide, it does provide the right to suspend work. So we talked about that. That's one of the new provisions in CASPA, where a contractor or a subcontractor can suspend work. Just since October of 2018. This was always in the New Jersey Prompt Payment Act, this concept, and it doesn't have the same kind of long, lengthy period of time and hoops you need to jump through in PA. It's a simple, this statute is very simple, straightforward. It's one page as opposed to several pages, and it says essentially contractors and subcontractors can suspend their work without penalty for breach of contract if they don't receive payments timely, and if there is no written statement of the amount withheld and the reasons for withholding. And here's the one wishy-washy point: no good faith effort to resolve the reason for withholding. So if there is a dialogue with the owner about, hey, we're going to make payment, there's an issue that needs to get taken care of, and we're acting in good faith to resolve this and work and get you paid, you can't suspend work in that case. It really needs to be a situation where there's no justification for non-payment, no written statement of the amount withheld, and simply payment is not being made timely. The good thing about this statute from a contractor's perspective is you only need to provide 7 calendar days written notice before suspending work. So you can put a lot of pressure on an owner or a general contractor very quickly if you want to go that route and say, my payment was due, and we're going to walk off the job in 7 days unless you get us, fully paid on the project. So it does provide similar rights as CASPA. You can access them a lot more quickly than CASPA does, which requires 70 days and several written notices before you have the right to suspend work.
Sounds like the New Jersey developer lobby didn't have as strong as a hold as the Pennsylvania developer lobby there. So let's talk about Delaware. Delaware, like Pennsylvania, is broken down into two statutes. One is for private projects and the other is for public. We're going to talk about private first, which is the Building and Construction Payments Act in Delaware. It applies only to private, not small residential, which I believe is defined similarly to Pennsylvania, with under 6 residential units being built simultaneously. One thing that we didn't talk about for Pennsylvania or New Jersey is a trust fund concept. Delaware is a state where even on private projects, funds that a contractor gets from an owner are held in trust for the subcontractors. That's a big deal, because when you're talking about the legal concept of trust, that comes with stricter requirements for accounting and for distribution. So if money comes in from an owner to a contractor and it's held in trust, it must be first applied, and it's for subcontractors' work. It must first be applied to that subcontractor's work, and anything else is going to be considered a misappropriation. And believe it or not, in this statute, it exposes the violator to either a fine or up to 3 years in prison. I can't imagine it comes up too much, because it's either fine or prison. But the point is that when you talk in trust funds, the obligations are more strict. Some states have that obligation on the public side, like New Jersey, but not on the private. Delaware is a rare state where private construction, there's trust fund obligations. New York is like that as well. Pennsylvania is not. So that's a new one there. Interest is recoverable for late payments. And interestingly, these construction contracts, whether it's between the owner and the GC or the GC and the sub, must by statute include a provision allowing for the recovery of interest. The catch is that the rate cannot exceed 5% annually over the Federal Reserve discounted rate, which of course is next to nothing at this point. So you're talking about 5% annually. Again, this is why I was telling you Pennsylvania is as strong as it gets, up to 24% total. Attorney's fees are recoverable. It is a substantially prevailing party standard. You need to prove that the non-paying party withheld those payments in bad faith, which is very similar to what we talked about in Pennsylvania. If you are withholding payment and you're not being specific and you're not doing it in writing and it's not tied to the actual deficiency, now you're looking at a bad faith type of situation. And the payer party, owners and contractors, they get 7 days to dispute an invoice in writing and with specificity. That is not a lot of time. I've seen nothing in the statute to suggest that that can be modified. It's just 7 days. That's even shorter than Pennsylvania, where the owner has to give 14 days. So you really don't want to mess around when you have an issue with an invoice. Get it in writing and do it quickly. All construction contracts have to be governed by Delaware law, so there won't be forum shopping if you have a developer that's from the Midwest and they say, hey, if we get into a lawsuit, you got to come out to Minnesota. That's not going to work. Delaware law is going to apply, and all the dispute resolution has to take place in Delaware. And the big kicker, which Pennsylvania and New Jersey do not have, is this statute on private jobs only. Pay if paid clauses are void and unenforceable as a matter of law. That's in the statute. So you put a pay if paid provision in a subcontract on a private Delaware project. You can put it in there, but it's not enforceable. It won't hold up in court. Shifting to the Public Prompt Pay Act, it applies to public works contract. It's usually all about funding from the state or a state agency. We're not talking about localities and municipalities unless we're dealing with a public school district, which is covered by the statute. Like I said before, another instance where the public statute is a lot weaker than the private statute, just like in Pennsylvania. So you can get interest on late payments, which is 21 days or more of non-payment, but the interest rate won't exceed federal prime plus 2% annual. So it's less than the 5% that you get on the private side. The court can award additional damages for wrongfully withheld payments, but it's a may. It's not a must. It's not a requirement. So that's going to be a tough sell because courts will often defer to taxpayer money, to localities. So you're going to have to show some real clear bad faith and a judge that didn't appreciate it to get that additional award. And it's, no attorney's fees. And lastly, pay if paid clauses are enforceable because they don't address that in the public statute. The pay if paid violation is only on the private jobs. So let me just see if we have any other questions in the queue. We don't have any questions. I'm going to give like a minute in case you want to type fast and furiously to see if you have any additional questions. I'll monitor the queue. Matt, did you have anything to add there to Delaware or anything else that we may have neglected to touch upon?
Well, the one thing that I wanted to point out was, you mentioned in Delaware that the statute requires that Delaware law apply to projects that occur within the state. And that's the situation as well for the New Jersey Prompt Payment Act and for CASPA as well. They both require the law of the state in which the project is taking place. That's the law that applies to that particular construction project, regardless of what it says in your contract that Minnesota law applies or whatever. The one issue is that, CASPA also says that, for example, in Pennsylvania, that disputes need to take place in Pennsylvania, but that only has limited, it only has limited applicability. Court cases need to take place in Pennsylvania, but there is the ability for arbitration provisions to make their way into your contract in Pennsylvania that require you to arbitrate outside of the state. And that's an issue of conflicts between federal law and the Arbitration Act, Federal Arbitration Act versus CASPA, and federal law applies. So the right to arbitrate anywhere, that's been adjudicated by the Third Circuit, and they said, hey, this says you have to arbitrate this project in Minnesota. You got to arbitrate it in Minnesota. Pennsylvania law may have to apply under CASPA, but the arbitration will need to take place per the contract. So that's one thing to look and be concerned about as you look at your contracts and reviewing contracts. If there is an arbitration clause, make sure the arbitration takes place the location of the project rather than wherever the owner or the developer may have a home office. So that's one point that I wanted to add.
Okay. All right, and perhaps one of the most important questions, can we get a copy of your presentation? The answer is, and I don't know if you have, the same control panel interface that I do, but there is a handout section in the control panel, and if you expand that with your arrow, you will see a PDF copy of the seminar slides. So you could definitely grab it from there. If you're not seeing it, or my instructions are terrible, which is entirely possible, I'm about to, here, the next slide will have our email and phone number, so you can always take that down and contact us directly. We'll be glad to send you the slides or answer any other questions you have. And oh, you got it. Okay, great. There is one substantive question, and we can wrap with that. Does language in a subcontract binding the subs to the terms of the prime contract that contains owner to general contractor payment schedules automatically satisfy the requirements of CASPA if the sub is bound to the prime contract but never receives it? This actually looks like a repeat. Has the GC satisfied the requirements by having the prime contract terms passed down? Sorry if I butchered that a little bit, but again, just to recap, the language is not enough. You want to put in the language and you want to give them the payment schedules, whether it's through the contract itself or whether it's just a copy and paste of the terms. You really want to inform them what those terms are instead of just saying, you're bound by the terms. Maybe I gave you the terms, maybe I didn't. You're better off just being more transparent, because otherwise you expose yourself to much less favorable payment terms by statute. It's no longer going to be tied to the receipt of payment. It's going to be the presumption that the owner has paid the contractor and that you now owe the money to the sub. So I would just, share that information in an email, however you need to do it, and do it that way. So with that, we're going to wrap up. I really appreciate, one, your time that you gave us, and two, a lot of good, thoughtful questions. You guys are clearly thinking about this, probably even stumped us on a couple, which is good stuff. So if you ever want to continue the conversation, you've got our phone numbers and our email addresses. And with that, we're going to close it down. So thanks so much for being with us.
Thank you, everybody.